start. We've got a lengthy calendar and a number of bills are going to take some time to go through and discuss. I want to welcome everyone. What I expect will be our last House Judiciary Committee meeting of this session. The first bill we'll have is Senate Bill 547, which I understand will be presented by Representative O'Neill. Is that correct, Mr. Representative O'Neill? Yes, Mr. Chairman. If you would, you remain in your seat if you'd like, and just present from there and tell us something about the bill.
Well, it's actually the Real Estate Commission bill, Mr. Chairman. If it pleases the chair, we have the Commissioner of Real Estate here with us, and if I could just ask him to
be happy to have him come
present.
forward.
But Commissioner,
please
if you would introduce
here,
yourself.
Thank you, Mr. Chairman, members of the committee.
Honored to have you, sir.
Thank you. Senate Bill 547 is essentially a bill that was passed last year by the General Assembly and then vetoed by the governor because of some technical problems in the definitions language at that time. We've worked with the governor's office and got that information out. We've also talked with the Realtors Association, the Appraiser Coalition, and we have general agreement on the current provisions. Basically, they are four. First, it would provide that members of the board or members of the commission must recuse themselves if they become the subject of a disciplinary action by the commission or the board in the considerations of that. Second, that the approved schools that the board and the commission have to approve, if they happen to be a business entity, must name an individual who will be responsible for seeing to it that the school complies with the requirements of the law and the rules. There's some changes that will allow the appraiser board's provisions to be more compliant with federal guidelines. And the one change from last year's bill is to eliminate a license. In the past, we have required licenses for corporations or limited liability companies that serve simply to receive commission payments for salespersons and associate brokers so that they can take advantage of various tax breaks. So we're eliminating that requirement, which will have the effect of reducing fees to those people and at the same time help make our agency more efficient in that we won't have to have computer programs to track those licenses. They will still be allowed to receive, those corporations will still be allowed to receive the fees, but we have created a special exception for that. I'll be glad to answer any questions anyone may have.
Thank you, Mr. Clark. Does any of the members of the committee have questions of Commissioner Clark? No questions of you, sir. Thank you so much.
Thank you.
Anyone else here wishing to speak either in support of or in opposition to Senate Bill 547? All right, so in the rest of the committee, we will have discussion among the committee members. Anyone wish to ask questions or make statements regarding Senate Bill 547? There being no further comments, we're ready for a motion. We got a motion do pass. Second motion or discussion on it, rather, excuse me. Second discussion on the motion. All in favor of the motion do pass of Senate Bill 547 as presented signify by saying aye. Aye. Opposed, like sign. That bill does pass. I'm going to look down the list. We have a Senate Bill 638, which is the aircraft liens bill. This is by Senator Chance. I don't think Senator Chance is available. We do have some individuals who are knowledgeable about this area. With the committee's indulgence, I'm going to let these gentlemen come forth and to speak on the bill. Please come up and have a seat, if you would, at the table in front of me. Senate Bill 638.
Thank you, Mr. Chairman. My name is Lee Hughes, and I'm representing Gulfstream Aerospace. I have with me today Don Anderson, an attorney from Atlanta who is particularly familiar with the laws regarding liens. Senate Bill 638 was introduced by Senator Ronnie Chance. There's a companion bill on the House side introduced by Representative David Knight. This was in response to a request from one of their constituents who handles insurance for aircraft, particularly aircraft that has been repaired. The code, I'm going to let Mr. Anderson explain the bill specifically, but Gulfstream became involved when they learned that they were going to address this code section. And just so you know, we have run this legislation by Delta Airlines, who is also supportive, as well as Lockheed Martin. The Superior Court clerks are also supportive of the legislation, as well as the Machinist Union, who is represented in the audience today.
All right, Mr. Anderson, why don't you slide that mic over to Mr. Anderson, and we'll have you tell us more of the details about why this legislation is necessary.
This legislation addresses aircraft mechanics liens, which is a specific, or aircraft liens are a very specific area of lien law, because the Federal Aviation Act and federal law preempts aircraft liens in general, and so it's important to have the state law consistent with the federal law in that area. This particular legislation basically takes two separate lien sections and combines them, or at least consolidates all the language relating to aircraft in one of the lien sections. Originally, 44-14-363, which is the general mechanics lien statute, included a reference to aircraft. And then there's another code section, 44-14-518, which also addressed mechanics liens for aircraft. So rather than having mechanics liens for aircraft in two different code sections, what we've done is we've taken the language from 44-14-363 and we've incorporated it into 44-14-518. So 518 now is the only code section, would now, as part of this bill, would be the only code section that addressed aircraft mechanics liens. It'd only be one place someone would have to look at.
Tell me about Section 1, where you're talking about the removing the term aircraft as a part of that section, because this is really I would say perhaps a misplacement of that section, that provision in that section.
In light of the enactment of the later section, that's correct, Mr. Chairman.
So we're taking that out. That's the only purpose of what we're doing in Section 1. Section 2 now sets up the, I guess, clarifying what is the things that can happen as far as repairs, fueling, et cetera, to an airplane for which a lien could be imposed.
That's correct, Mr. Chairman.
Okay.
And basically what the additional language of 44-14-518 does is it also incorporates a federal filing provision. And the Federal Aviation Act, as interpreted by the U.S. Supreme Court, preempts state law as to the place for recording liens on aircraft. And so the way the existing statute read, it actually provided for recording liens in the county clerk's office. And a recording in the county clerk's office would not be effective, and the federal law would preempt that. In fact, there's a Georgia Court of Appeals case that basically says just that. It says that filing in the county clerk's office would not be effective and the lien would not be valid because federal law controls. And so what this bill will do is it'll provide an outline or a checklist for anyone who wants to file such a lien. It'll tell them that they need to file it in the FAA aircraft registry, which is in Oklahoma City, Oklahoma. It will tell them they don't need to file it in the clerk's office of the county court because that has no effect. And it also provides that there will be notice given by the person claiming the lien to the owner of the aircraft or to others who hold a recorded interest in the aircraft. So that way there won't be a lien that surprises someone 2 or 3 years later. They'll know once the lien's placed, the owner of the aircraft and the lender on the aircraft will know that lien has been placed.
Right. Thank you, sir. Mr. Anderson. Any questions of the presenters? I have Mr. Tilley.
On page 2, lines 13 and 14, it says, this is new language, such liens shall be superior to all liens and second liens for taxes. Who are we jumping in line?
That's an excellent question. Actually, that language comes out of section 363. Unfortunately, the only portion of 363 that's amended is subsection C1, but actually section 363A actually has exactly that language in it. So what we did is we carried over that language from 363A and put it in to this new section 518, so that aircraft liens will have the same effect that other liens would have.
So it's already second to taxes, or?
It's already second to taxes. The other provision that we have talked about is whether there should be some language in here that says, except as provided by OCGA section 11-9-333A, which is the Uniform Commercial Code, Article 9 of the Uniform Commercial Code. And we've researched that, and basically in looking at 44-14-363 for general mechanics liens, the Georgia courts have interpreted mechanics liens as being subject to Article 9 liens anyway. So it could be.
And Mr. Chairman, in our process of going through this with Representative Fleming as well as the speaker's lawyer, Mr. Cho, that was one recommendation. That's the only recommendation that we have to change the substitute you have before you, if we can add that clause referring to the Uniform Commercial Code.
Although what you're saying is case law, Mr. Anderson, you say addresses that point?
It does, Mr.
Under the
Chairman.
old section.
So even without that change, the case law would have that effect.
Okay, I don't think what let me back up and say this way. We're not going to be doing something that will have an impact upon existing or to be filed in the future security interests on planes.
No.
In your opinion?
We would not. Of course, the lenders in this area know that the way they have to perfect those security interests is by filing them with the FAA in Oklahoma City. So, assuming they file and properly perfect their security interests, then this would not change.
Well, we look in the title law priorities. You got a pre-filed security interest. You're not going to defeat that or change that by the language you're saying in here that says it's going to be superior to all liens except tax liens.
That's correct, because the way that the Georgia Court of Appeals has interpreted Article 9 in Georgia, there's language in Article 9 that basically says the Article 9 security interest has priority over mechanics liens, and that's already in Article 9.
Yes. Did you have a question, Mr. Corbett? I know you had your hand up earlier.
Yes, I do. Mr. Chairman, if I could ask the presenter,
certainly.
On page 2, line 32, you've got a notice provision in here that could be by fax. Is that correct?
That's correct.
How are you going to have a verification of timely receipt by fax?
I would think it would be the fax transmission receipt. In other words, once the fax goes through, there's usually a receipt that comes through from the fax machine that shows that it was received or that it didn't go through or something along those lines.
Mr. Chairman, a follow-up question.
Yes, sir.
To you, and we have a former chairman of this committee in here too, and over the years, this has been one of the things that this committee has always been very much a stickler for is notice provisions.
Notice, yeah.
And I do not like the fax or providing a copy by electronic means, because just because you send it by fax doesn't mean deemed that even though you have a receipt, is that deemed to be received?
Ask me and Mr. Anderson.
I'm asking you, Mr. Chairman. I mean, what's your opinion?
I don't think we've broadened our abilities to speak of having appropriate servers which may constitute notice to recognizing facsimile or other electronic means as appropriate at this point in time. I think we've got some concerns there.
I have some concerns on leaving that in this bill, and it's not only because of this bill. It has to do with following any other lien bills that may come through here.
All right. What's your thoughts about that, Mr. Brumby? Okay, no thoughts. All right. Ms. Oliver, you had a question.
I have a second, Mr. Airport.
Of course. I believe that's true. And I'm a resident of DeKalb County and often out at that airport and work with many of those people directly, and in fact also represent, during the course of my law practice, many of the lenders. And this basically, I think this legislation will be salutary, because if someone follows the existing statute, it's a trap for the unwary. They'll file something with the clerk of the Superior Court. That won't have any effect, and they'll find that they don't have a perfected lien. This will really give them a checklist. It'll say, file your lien in Oklahoma City with the FAA Aircraft Registry, and it will also give the owners and the lenders notice when there's a lien filed against the aircraft. There is. Oh, yes. I beg your pardon? They have not. I'm a member of the aviation section of the State Bar, and unfortunately, it hasn't been as active as it could be. So, it really would be helpful if we would substitute.
Anything else, Ms. Oliver? Got it. Anyone else have questions of the presenters? You had a puzzled look on your face, Mr. O'Neill. I thought maybe you had some questions. All right. Anyone else here to speak either in support of or in opposition of the bill under consideration, Senate Bill 638?
Mr. Chairman, if I may, certainly the language about facsimile or electronic transmission is we have no heartburn if that's what
we're going to probably take that into consideration when we get to the committee's review. Yes, sir. Your name?
I'd like to speak on the bill.
Would you like to come around? Did you sign up? Do we have your name?
No, probably not.
All right. Please come up here and let you can stand if you wish, or if you're going to be a few minutes, we'll give you a seat. But the thing we'll do is have you give your name to the committee, please. And
yes, my name's David Edwards, and I represent the International Association of Machinists and Aerospace Workers. And a lot of the guys that I represent, men and women both, they do a lot of repair on aircraft mainframes, engine power plants throughout the state. And I just was made aware of this piece of legislation earlier today. Haven't gotten referral back from legal counsel as to a position from the Machinist Union, but I'm certainly in favor of anything that would make it more streamlined to where the men and women that will be working on these aircraft have a way to get their money back and for services rendered. And that's all.
I think that's part of the intent. Make sure you got a security interest after you do the work. Thank you. Thank you, Mr. Clark. Anyone else wish to speak on the bill? We will take it to the rest of the committee this time and open up for discussion among the committee. Anyone have comments?
Mr. Chairman, at the proper time, I wish to make a motion for an amendment.
All right, sir. No comments or discussion. We'll entertain a motion. A motion do pass. Do we have any discussions on the motion? I think we can get you a moment or two to look at your amendment if you'd like, Mr. Crawford.
Mr. Chairman, I would propose as an amendment to whichever number we're looking at, to SB 638, and on page 2, line 32, between requested and statutory, I believe that there should be a or placed there. And then after delivery, the period, striking the balance of line 32, all of line 33, and and striking the first 5 words of line 34, ending after addressed.
So, read us how you will have it proposed if your amendment passes, please.
Beginning on page 31, it will say, by personal delivery, certified mail with return receipt requested, or statutory overnight delivery to the following.
Okay. So we drop the comma on line 33 after requested.
Yes, sir.
Insert there the word or, and then after overnight delivery, comma, and then to the following. Okay.
Yes,
does everybody understand the motion? Any discussion on the motion? The motion to amend.
Hold on, let's see, just a minute. Yes. I want to make sure I didn't miss it. Did we miss it somewhere else? Okay. Oh, okay. Let's move that amendment first, Mr. Chairman. Right. I think there's another one that the presenter brought to my attention.
Further discussion on the amendment as presented by Mr. Crawford. Ready to call the question on the amendment. All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. The amendment carries. Do you have any other amendments?
Mr. Chairman, the presenter brought to my attention under section 2, page 2.
Line 13.
After the word therewith. Yes, sir.
That there should be inserted
Except as provided by OCGA 11-9-33, parentheses, small a, close parentheses. I think that would take care of your UCC problem that was discussed.
All right, so would you,
Here, I've got it.
would you have that read, or
I'll give it to
Chad read that, Chad, excuse me, Josh, read that as we would have the sentence read with the amendment.
Still have the period at therewith on line 13, starting a new sentence, except as provided by OCGA section 11-9-333, paren A, paren, comma, such lien shall be superior to all liens except liens for taxes.
Discussion on the amendment. Does everyone understand the amendment? Discussion among the committee. Any discussion? I think you might want to deliver that to Mr. Brumby. Let's be sure he's got the language to incorporate as a part of the committee substitute. We have the bill passed. Any further discussion on the amendment? The amendment's called. All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. The amendment carries. Any further amendments among members of the committee?
Thank you, Mr. Chairman.
Yes, sir. Further amendments. We're ready to call the main question. The question is to pass Senate Bill 638 as amended as a committee substitute. Any discussion on the motion? All in favor of the motion signify by saying aye. Aye. Opposed, like sign. We have a due pass. Thank you. Thank you, gentlemen. Representative Setzler, I think I saw you in the audience somewhere. There you are. Come forward, please, sir. You're on House Resolution 1558. And I'm still curious why we got this.
Okay. Thank you, Mr. Chairman, members of the committee. I'll try to be brief. I know the hour's late. I appreciate your making consideration of House Resolution 1558. House Resolution 1558 seeks to establish a House-only study committee to study the issue of bioprivacy here in Georgia. The study committee would look to take a holistic view at emerging technologies and how they impact certain privacy rights of citizens here in Georgia. Some of the technologies in question, some of the things that the committee would address would be DNA profiling and genetic profiling, certain technologies with respect to identification, RFID, retinal scan technologies in public, private employment in various contexts. Some of the concerns that helped bring this to my attention was the state of California in 2004 passed a proposition that effective at 2009 will require that for all folks arrested of felonies, not charged, but arrested for felonies, will have DNA collected and maintained within a state database. That was, again, I've got some information in your packets that speak to that. The concern is, under what context is it appropriate to collect certain indelible biological information? There's a pretty well-established practice within the law enforcement communities with respect to, upon probable cause, certain things being collected. But what the study committee wants to do is simply look at what, as technology emerges and evolves very quickly, what's the appropriate context in which certain information can be collected by private sector employers, public sector employers, in certain contexts with respect to the law enforcement community, or even in retail outlets. If any of you have been to Walt Disney World within the last 18 months, currently to get access to the Magic Kingdom, folks going through the gate are asked to give 2 fingerprint IDs. I went through with my family back in October of last year, and as my wife was going up to give her fingerprints to get access to the Magic Kingdom, I said, Tracy, could you wait a second? I asked the attendant, I said, why is it that we're giving fingerprints to get into the Magic Kingdom? We've got our tickets here. And she insisted, it's not a problem. This is just a way that if you lose your ticket, we can check your fingerprint against the ticket and make sure that it's your ticket and reissue you a ticket. But my concern was, under current law, a fingerprint or subjecting yourself to a fingerprint is you're subjecting yourself to a Fourth Amendment search. And I asked the lady, is there a way we can get in without this? And she said, yeah, we can get you in. And she worked it out with her. And we got in with just by showing my photo ID card. But the concern was, who's maintaining this information? What's the context in which it's purged, and or is the Walt Disney Corporation maintaining this? It opens a whole number of questions with respect to privacy, and that's just out of my personal experience. 2001 Super Bowl, it's widely known that facial scans were taken of everybody who went in the gate to check against an FBI database for certain digital criminals. Those kinds of things, I think, create enough concern that we ought to study the issue holistically and ask some of the following questions, and I'll wrap up with this, Mr. Chairman. Should insurance companies, and these are just hypothetical questions, these are some of the things we would address in committee. Currently, insurance companies, as I understand, in making assessments for coverage, look at existing medical conditions and medical history when they consider insurability. Would it be appropriate for, given how easy it is to take DNA information, would it be appropriate for an insurance company or a business that would seek to employ you to take DNA, do a genetic profile of your propensity for certain diseases, and if it's found that Mr. Setzler has a 90% chance of getting colon cancer by the time I'm 60 based on my genetic predispositions, would then be uninsurable? Now, these are the kind of questions that really, with respect to certain technologies, concern me, and I think we as a state ought to at least study holistically. And it's with that spirit that I'd like to ask approval and favorable consideration of a study committee for the summer.
Thank you, sir. Any questions of the presenter? All right. I see Mr. Lindsay's on your bill with you, or your resolution. I'm sure he's well versed on this area then.
Mr. Chairman, I spent, if I may, 30 minutes with the assessor, and I had no idea how much I did not know. But after 30 minutes, I really decided that this was something that really was thinking outside the box, dealing with issues that I decided we would face over the next 10 to 15 years. And I thought it was a good time for us to try to get a handle on it.
Okay.
Study committee might do it.
Thank you, sir. No further questions of Representative Setzler. We'll move on. Anyone else here to speak either in support of or in opposition of this important resolution? Yes, ma'am. Come forward and give us your name, please. And
I don't need to say anything more than what he said. I just want to say I'm Maggie Garrett. I'm with the ACLU of Georgia, and we strongly support this resolution.
ACLU supports it.
That's correct.
All right.
Sorry.
No problem. You want to ask Mr. Setzler anything? I just want to be sure before we get to the question. We're going to go into the discussion in a minute. Thank you, sir. Anyone else here to speak in favor or in opposition to it? We will now take it to the rest of the committee. Discussion among the committee members. Ms. Oliver. We have a motion due pass. Any discussion on the motion?
Mr. Chairman, I wonder at some point I think that we will have a real
Yeah, I don't think this committee controls that issue. Yeah, that's something you can certainly raise with appropriate groups. Fine for that. All right, we have a motion do pass. Any further discussion on the motion? All those in favor of the motion do pass signify by saying aye. Opposed, like sign. The ayes have it. Your resolution does pass. Welcome to rules. I'm going to next take up, I believe, the we don't have, Senator Hill, you're behind. I can see you there now. Okay. Do we have any other senators here in the room? I'm sorry. Come around, please, sir. The reason I'm holding yours up is going to take a lengthy time, I think, discussion-wise. I'll try and get those that are not going to be lengthy, first of all, out of the way. Come up front, please, Senator.
Thank you, sir.
Nice to see you, and glad you had first time. I believe you've been before our committee, Senator Tarver.
First time I've been before any committee.
Is it? Okay. Well, we're going to be very friendly with you.
Well,
I don't believe what you've heard. We're on Senate Bill 622.
Mr. Chairman, I'm Senator Ed Tarver. I'm here to present Senate Bill 622. 622, SB 622 proposes some amendments to the Georgia Hospital Acquisition Act. Under the current act, it requires notice to the Attorney General's office of the sale or lease of 50% or more of the assets of a nonprofit hospital. It also mandates a review of the sale or lease of the transaction by the AG's office, regardless of whether that purchaser is a nonprofit or a for-profit entity. The bill as presented would propose some amendments to the existing statute. The First Amendment would provide or allow the parties to a transaction to submit a signed acquisition agreement to the AG's office as part of their notice for review. Under the current act and case authority that interprets the act, that is not permitted, and that flaw has allowed unilateral withdrawal from the transaction either prior to the hearing, the public review by the AG's office. One of the amendments to the act would allow for the signed acquisition act to be presented contingent upon the completion of the notice to the AG's office and the public hearing, and also contingent upon allowing the parties to modify the acquisition act should any issues be raised during the hearing. The second amendment to the act would provide some additional flexibility by allowing the parties to submit the required documents to the AG's office at any point following the submission of the notice of review. When this matter was presented to the Senate, there was an amendment proposed that was supported by the AG's office and also by the Georgia Alliance of Community Hospitals, the Georgia Hospital Association, and the Georgia Hospital Association, that provided that that in terms of the submission of the documents, that they be submitted not later than 14 days prior to the holding of the public hearing, and that they be available for public inspection at the hospital being acquired not later than 14 days prior to the public hearing. A third amendment to the act would allow, in the case of a unilateral withdrawal from a transaction, that the seller's notice requirements for a subsequent transaction with a new purchaser be reduced from the 90 days to 30 days. Mm-hmm. Right now,
the whole process again.
It's supposed to go on starting the whole process again. Right now, from the time that the parties submit the notice of hearing to the AG's office, they have to wait 30 days before they can close the transaction. The Attorney General's office has 60 days to schedule the public hearing, and this would the revised period of 30 days would fall within the 60 days allowed by the current act, but it would also allow the parties to continue to proceed with the transaction as quickly as possible.
All right.
And then finally, an amendment that was proposed by the Attorney General's office would allow, would cap the cost. It would allow the Attorney General's office to retain consultants or experts to assist them with their review of the transaction. It would cap the cost of those services at $60,000, and it would allow the parties to pay that amount for the services directly.
Assessed against them?
Yes.
The buying party or both? Or?
It would be against both. Shall be paid directly to each of such experts or consultants by the parties to the transaction in a proportionate amount. So it would be a portion between the parties to the transaction.
Thank you, Senator.
Yes.
Any questions of the committee members of Senator Tarver? Yes, sir. Mr. Fleming.
The parties to the transaction pay, but under the current statute, it requires that the $50,000 payment be made to the AG's office at the time the notice of hearing is notice of transaction is provided to the AG's office.
So what change are we making?
It would allow, as opposed to the money being paid directly to the AG's office, it would allow the parties to make those payments directly to the consultant that provide the service.
And what was the idea behind that, needing to do that?
Right now, under the current system, even though the AG receives the money, they still have to apply as part of the appropriations process to receive the money to pay those consultants, and it's developed quite a backlog. As I understand it, there are some consultants who have provided services in regards to these transactions. We've waited 8, 10, or even longer than a year to be paid, waiting on that money to be included in the budget for the AG's office so that they can pay them. This would allow those consultants to be paid faster and that people to be paid directly to them.
So would this take, if I may, Mr. Chairman, would this take the appropriation authority for this issue away from the General Assembly? No?
I don't think it will.
Okay.
Anything further?
Well, Mr. Crawford, can you seem to...
I'll get him in a second.
Mr. Chairman,
coming around the table. Anybody else right now? Mr. Crawford.
Mr. Chairman, we have to appropriate those monies each year, and what's happening is, like in this budget year, the AG's office, and there's some of the AG staff here that can shed some light on this for you, but this year there's a proposal, I believe there's a understanding that there should be one of those nonprofit hospitals in the works. Am I correct in that? And what we try to do, we ended up having to, it's a question of when you fund it, but it's through the appropriations process that we fund this. And the AG's office is required by statute to pay all of these consultants and to pay these bills. And one of the things that is happening is it depends on when that transaction takes place as to when they get paid, and sometimes we're having to reimburse the AG's office through the process as a catch-up, and they have to juggle monies, but to make sure that normally they've been running about $50,000 by the time they hire all the consultants, and they do a wonderful job. The AG's office does. The consultants of being able to make these things happen, and they made one. Was it last year? I made one happen in very short order. I mean, down to the wire from not happening. So this is a good bill, proper time.
We're going to talk more about it. Yes. Anyone else have any other questions of the presenter? All right. Anyone else here to speak in support of or in opposition to Senate Bill 622? It'll be in the breast of the committee. Any discussion among the committee? I guess one thing, if I may, I sometimes try to think like a lawyer does. The language I'm wondering here about this 30 days, I'm just curious, would there be a means, and maybe the AG's office, who's here for the AG's office? If you could stand up, let me just ask you a question. On this 30-day, after you've had the 90-day, and now that contract falls through and you go to the 30-day, my real curiosity is, could the parties set up what I call a straw contract, run through this 90 days, and then a means of shortening the time for your real review, get down to a 30-day? Does that make any sense?
Mr. Chairman, my name is Dan Formby. I often appear as a hearing officer in these
yes,
acquisitions, and I believe this provision is directed toward the fact that it would enable the parties to close immediately after we render our report. So I think it does speed up the process some and enable them to close as quickly as possible.
I guess I don't understand how that full transaction works. They submit a contract that's going to be what I call a straw contract, knowing it's not going to close, just to run through the 90 days. Are you able to, if that contract doesn't close, does it in any way hinder your abilities when they walk in with another contract? It also doesn't say what period of time there has to be a second contract brought in. It could be 30 days afterwards or 3 years afterwards.
Still, the statute does provide that.
Does it? Okay.
Within 1 year period.
I'm reading parts of it here. But does it hinder you in any way, or I say you, the AG's office, in your way of doing your review, if now you're under a 30-day limitation before they can have a consummation? Or can you stop them from doing it if you say, wait, you're not going to do it until we're through with our review?
We will be able, Mr. Chairman, to do our review, to have a period of time where we have the public hearing, and then after the public hearing process, have 30 days to do our complete review. Okay. It does not shorten our review period,
okay.
But it does enable them to close more quickly.
I'm clear on that then. Thank you so much. Anyone else have any comments or thoughts? We're ready to entertain a motion.
Mr. Chairman, I would move due pass on Senate Bill 622.
All right, we have a motion due pass. Any discussion on the motion? Any amendments to the bill? Proposed amendments? There are no amendments. We'll take the motion. We're ready to pass the motion. All in favor of the motion due pass signify by saying aye. Aye. Opposed, like sign. You're successful, Senator Tarver, without even an amendment. That's something we don't do often.
Thank you, Mr. Chairman.
Thank you. Good to see you, sir.
Tell the other people over the Senate that just whining when they say we keep
Somehow, how we treated you.
You had no problem at all.
All right, I know I've got Senator Harp's bailiff bill. If you bear with me just a little bit more, Senator Hill. 563, I told him we could take that without his having to be present. It's a fairly short bill. This has changed the compensation of court bailiffs in the Superior Court, and as I recall, it hasn't been changed in a number of years. I forgot what the time is, but this is just to have it go from an amount not to exceed $70 to an amount not to exceed $100. Move due pass on Senate Bill 563. Any discussions on the motion to pass? All in favor of the motion due pass signify by saying aye. Opposed, like sign. We have that passed. I'm going to hold up Senator Bullock's living will form unless somebody wants to. Anybody here to own that form right now? You going to present it? Oh, is it? Ah, hiding behind me. Good to see you there, Senator. We'll bring yours up. And I was saying to Senator Hill, I know his is going to take a little time to present and talk about, so I wanted to go ahead and get other shorter bills out of the way. All right. You got Wiles also? 101? We're on the Senate Bill 588. 588.
Thank you, Mr. Chairman, members of the committee. This is a very simple bill. I think it passed unanimously out of the Senate committee and House, or Senate committee and chambers. It simply is a first small step in protecting ourselves from the ever-growing crime of identity theft, and this would prohibit someone or a company from publicly posting somebody's Social Security number except under certain conditions. The good thing about this bill is it's been met satisfactory with everyone on the entire scale, from Equifax at one end to privacy concerns on the other end. So we've had zero opposition to it.
Excuse me, I'm going to turn it over to Vice Chair Lindsay. Yes. I'm going to have to go present a bill to Senator Collins.
Senator,
yes, sir.
I just have a quick question.
I agree with the premise of the bill and everything. I'm just sort of curious on what real impact a Georgia law is going to have on the internet.
Well, real impact, I guess, would be hard to gauge.
Yeah.
I have a data security expert here who will be willing to come testify. I do want to mention one thing, if I could. I apologize. Section 2 was added on the Senate floor, and it really has nothing to do with what we're trying to do here. And I would ask if it's okay that we amend this bill to completely strike Section 2. And I know that may be a main way to talk about that later.
Okay.
But, Mr. Chairman, I got a question. Yes. I got a question for Legislative Counsel, Mr. Chairman, if possible. Beginning on page 1, line 22, and going through line 15 on page 2, would this wording allow the clerk's authority to post this? Now, let me, I'm for your bill, Senator. I'm not trying to cause you a problem, but let me ask this. These mortgage documents, security deeds that have someone's Social Security on them, the Social Security number on them, the clerk would file those, which it says that the clerk shall be held harmless for filing, publicly posting. However, those documents are all transmitted to the clerk's authority, which is if I'm not mistaken, is a separate entity from the clerk. And then I can pull up that security deed. I can pull up that security deed with a Social Security number on it. Or I can pull up the UCC documents. I can pull up all of that off the clerk's authority.
I think the point made is well taken, but I don't know that I have a positive answer to the clerk's authority law. In essence, the guy
Would the senator oppose that? Are you following what I'm... The clerk would file documents that may have these Social Security numbers attached to or on them. And those are transferred to the clerk's authority. If I have an account and a password with the clerk's authority, as most attorneys in the state do, I can go in and access those records, and those records will appear with that Social Security number on it. And I personally felt like when I read it that under Section D on page 2 that maybe the Superior Court clerk's authority should be added there to be held harmless if those documents will first have to be filed in the Superior Court.
Mr. Representative Crawford, I don't have any problem with that. Are they required by law to post those?
They sure are.
If they're required by law,
that's what
I would think that line 23 and 24, which says the collection, release, and use of individual Social Security numbers as required by law.
But they're not. The problem that I read what you're saying, they are not necessarily required to have the Social Security number to be posted. They are required on documents by lenders or mortgage companies to have them on the documents. They're not required by law to be on those documents, to my knowledge, but they may be a requirement for the loan.
I have no problem adding the bill at all.
Sewell, am I getting too far reached in this?
No, I think it's a legitimate concern, but I think probably doesn't take the bill.
If we just added Superior Court clerk's authority in Section D? Okay. Is that okay with you? Okay.
At the appropriate time, I'll entertain a motion. Any other questions for the author of the bill? Anyone else here to testify regarding the bill?
We have a data security expert.
Okay, maybe you can answer my question. I like the bill. I like it a lot. I just want to know how effective it's going to be as far as our ability from the Georgia legislature to put some type of restraints on these things.
Yeah, the real impact of this is
Okay.
And maybe a few companies who are just totally irresponsible. But I think primarily this is going to address criminal activity of selling information on the internet. I would like to just add one comment that in the FTC statistics on identified reports for 2005, the state of Georgia ranked 9th in reports of getting theft. And I think this should really be a concern to the state. And although this is a very small, specific measure, I think it's worth taking. I think it's been very well thought out, and it brings value.
Okay. Any other questions for the witness?
Mr. Chairman, and to follow up on that point, it would apply to Georgia residents who are engaging in this kind of conduct. And I know that, for example, Equifax is based here, so that's a pretty significant actor.
I'm sorry. Yep, hold on. Let's see if anyone else wants to. Anyone else have any questions?
I have a question, Mr. Chairman.
Yes.
Senator, I was trying to read the bill, and I was reading the little write-up we have on it here, and it says that you'd have to have
internet site with a password, and the website is secured. The password I understand, and I assume that's right there. And is that in the bill where it talks about having to have a password? Is that the encrypted language on line 18 on the first page?
I think 19.
No.
18 would be encrypted. 19 would say the Social Security, and 20 would actually say the password needed to be included.
And that's where we get secured from. Once you have the password requirement, you're therefore secured. So we're not using the word secured in your bill anywhere. I was worried about the definition of that. That was my question.
Okay.
Thank you.
Mr. Orrock, you want to...
Danny Orrock with Georgia Watch. I just want to say we are in full support of this bill. It codifies good practice regarding Social Security number. Good anti-crime bill.
Good.
Jill Johnson with Georgia Clerk asked me to add her support too. She's in another meeting.
That's good. Strange bedfellow. Anyone else wishing to speak on the bill? Something you wanted to add, and then I'm going to get to this gentleman, because you already said it.
Just on the previous discussion, other states have been wrestling with this issue of public records being posted electronically. And so what other states have done is in public records posted those documents, but then masked or blocked out the Social Security numbers. And I only offer that as input.
Mr. Chairman, can I ask a question about that?
Sure, go right ahead.
What's the difference in that and going to the clerk's records and pulling them? I mean, they're a public record. I believe, if I'm not mistaken, and we have someone with the clerk's authority, I don't believe that you can alter from. I don't believe when the authority was set up, and Senator Wiles, I think, was here when we did all this too, that we and Senator Oliver, Representative Oliver, may have been the only other ones here. I believe that part of the law on the authority is that all documents must be submitted and they cannot be altered. Isn't that correct?
That is correct.
So we could not, under Georgia law, block out those Social Security numbers, I don't think, unless you go back and change the authority.
Yeah, I guess I would just offer to you to consider that the size of the audience and the number of people that can view the information on the internet is significant compared to people being in person. And so I think it's really kind of a separate issue that was not the main focus here, but I only mention that other states have wrestled with this because you need to ask the question, does the document itself need to have the Social Security number in the first place? Is it essential to whatever but that's almost like a separate
I think
issue.
I don't want to see us criticize an apple for not being an orange, and perhaps I think the representative as well has a good point. We need to perhaps take another look at that next year. I do want to get to this gentleman here, and then I want to hear from the clerk's office on the point raised by Representative Crawford. Yes, sir.
Yes, my name is John Millett. I'm the Chief of Staff for Senator Sam Gamma-Ripper.
Yes.
I just wanted to speak on behalf of the Senator, saying that he wholeheartedly supports this bill.
Mm-hmm.
He also supports Senator Rogers' request that Section 2 be deleted.
Thank you. If I could just sort of get you to chime in from the clerks.
Very quickly.
Please.
Mike Holloman, I represent the Council of Superior Court Clerks, Association of Superior Court Clerks, and Superior Court Clerks Cooperative Authority. And those are actually all separate entities. You are exactly right, Representative Crawford, that the Superior Court, as all of you know, is court of record. Documents, once they're filed in a court of record, cannot be altered. They become a permanent record of the court. The Superior Court is governed under rules of the Georgia Supreme Court. The Georgia Supreme Court has repeatedly issued Rule 23 that all records in the court are public records, and the authority is the receiving entity. Y'all have hit exactly on our solution to the availability of these records is don't put them in there in the first place. But there are almost 300 million images on our database. To suggest that we could blur out, and remember they're just an image, they're not searchable. First of all, some human being would have to go through 200 to 300 million images, read every bit of that image, and then somehow blot out electronically the information. It's not like you can search and go say, find all Social Security numbers in these close to 300 million images. It's not that easy.
Well,
it would shut the authority down, and we.
I appreciate that, and perhaps during the off season you can get together with some folks and see if there is a solution. But like I said, for right now, I'd like to see us sort of focus on this bill, and what we can do in terms. Does anyone else have any other comments on the bill? Yes, go ahead.
So I just want to make sure I understand, Mr. Holloman. Mr. Crawford's talking about inserting the clerk's authority as being exempt, and that's going to solve your problem?
Yes.
Okay. And now, as far as superior court clerks all around the state, I know they have real estate records online. I think that's through the authority, right?
That's correct.
And the UCC filings are also.
And I know when I want to go look at a court file, I go to the clerk's office and they hand me the file and I look through it, and that's where there could be some records that were entered at some point in court with Social Security numbers right now.
Mr. Chairman, can I respond to that?
Yeah.
A lot of your mortgage documents will have on your security deed, local banks will require it, that Social Security numbers are appearing on security deeds and financing statements.
Well, we're going to solve that by putting the clerk's authority exempted, right?
That we're going to limit their liability.
Here's where I was going with my question. I don't know of any. Are there any Superior Court clerks around the state who are scanning in other documents that go through a trial?
No, not trial documents.
Okay.
No, just real estate.
That doesn't happen anywhere?
Yeah.
Okay. All right. That's all I have.
Not yet, but I think that day is coming.
And one follow-up.
Sure, go ahead.
Right. Mr. Senator Rogers.
Yes.
Yeah. I apologize for stepping in a little late on this, and I'm sure that and the word Equifax came up. The people who deal with these kind of numbers all the time, they're okay with this?
That's about favorable in the last.
Okay.
Thank you.
Very good. And if I understand correctly, you want Section 2?
I would like Section 2 eliminated.
You're certainly the authority on legal and illegal aliens in this General Assembly this year. All right. And anyone else wishing to comment from the audience? All right, I'll take it up among the committee. Any conversation among the committee? Do I have a motion?
We do pass.
Okay. And I believe,
Mr. Chairman, I would have two amendments.
Sure.
The first amendment would be to strike Section 2 as asked by the author and renumber Sections 3 and 4 accordingly.
Mm-hmm. All right. Any discussion on the amendment? All in favor signify by saying aye.
Aye.
Any opposed? All right. And your second amendment?
My second amendment, Mr. Chairman, and if the author would look with me to make sure we insert it in the right spot, on line 13 on page 2, after the word state, insert and the Superior Court Clerk's authority.
Should be Superior Court Clerk's authority of the state.
I mean, yes, the Superior Court Clerk's cooperative authority. You're right. I'm sorry.
Doesn't need to say of this state.
It's the Georgia Superior Court Clerk's authority, whatever the proper name of the clerk's authority is.
Is it? Well, let's ask the Georgia
Superior Court Clerk's cooperative authority.
Georgia Superior Court Clerk's cooperative authority. All right. Any other additions?
Maybe member thereof, because Cobb County puts it on. The clerk of Cobb County puts the same documents on there. And they're not. So you speak. But he's the clerk of authority.
That's already covered under the clerk's.
Clerk of the Superior Court. Look on page end of line 12.
It things like, when you put ask for an MVR, like the speaker dinner tonight, move it. You put in Social Security.
Tell him that that's what you're going to do later.
As long as it's for a purpose.
If he says okay, it won't be a problem.
Right, as part of an application or enrollment process.
Okay.
This is the third party checking with another party.
Well, let's deal with Mr. Crawford's amendment first, and then if you've got something in addition you want to add to it, if you don't mind. So let's deal with this one at a time. I just want to make sure that we get this cleaned up first. We're working on it, Senator, I promise. Senator Tarver didn't seem to have a problem getting that. But
you said we do to former members.
Just to make sure, why don't you restate
Mr. Chairman.
Yeah.
After, on line 13, after the word state, insert the Georgia Superior Court Clerks Cooperative Authority.
Okay.
With the word and the Georgia Superior Court Clerks Cooperative Authority.
Any discussion on the amendment? All those in favor signify by saying aye.
Aye.
Any opposed?
Thank you, Mr. Chairman.
Ayes have it. All right. Any other additional amendments to the? Okay. Okay. Now turn to the bill. All those in favor of giving a due pass on this bill signify by saying aye. Aye. Any opposed? Ayes have it. Senator? You've had a long day, sir. Thank you for your comment.
I'll take over this point. We're going to do Senate Bill 427. Senate Bill 427. Oh, is Wiles here? Hold on. Let's talk Wiles' bill. I'm sorry. They're going to call you when we got through. Okay. This will be Senate Bill 101.
Thank you, Mr. Chairman. I'll be very brief. Ladies and gentlemen, I appreciate you accommodating me. We just had a Senate Judiciary meeting where I had to go over and provide a quorum. We did all right by the House members. Senate Bill 101, and I wish I had a copy, and I apologize for not. It's a bill I've been working on for several years, and it simply basically establishes the policy that we have an elected judiciary, and if a plaintiff in a lawsuit
where is
it? Comes forward and decides that they want the elected judge of the court where the case is pending in the state of Superior Court, that they can request an elected judge hear their case, and the judge, unless there's exigent circumstances, will hear the case. We've had a lot of discussion. We had a lot of discussion in the Senate Special Judiciary Committee and the Senate Judiciary Committee. And basically, when I first brought it out, it said shall, and it didn't give an out, and that was wrong. I just admit to that. I mean, over the years, I'm working on this, and there's a lot of reasons that you can't have it. For instance, let's say when we had in Cobb County, one of our judges was handling the crematory cases, Judge Bodiford, and he was up in West Georgia for a long time. And so this says, but it addresses some of the concerns you have. There are some courts, I know it might be a surprise to many of you that practice in other areas, where you do never, ever see an elected judge on cases that you file in Metro Atlanta. You show up in one county, and the entire state court calendar is handled by part-time magistrates. And the only time you see the elected judge in that case is if there's a jury trial demanded, it's kind of an interesting concept. I mean, in my own county, in Cobb County, the state court handles all their calendars, but there are many places where they don't. And actually, this came not because of my action. This came from an attorney in Cobb County who was frustrated that when he had a divorce case, he had two judges sitting by assignment give two different rulings on two children, and he had to wait 3 months to get the Superior Court judge to resolve the conflict of the two other judges that were handling the case for the Superior Court judge. And he said, if I just had the one judge, even if I just had one judge, as opposed to having, in essence, three judges in a case involving children. And so some of the concerns I'd heard was, why not the defendants? Well, my fear is the defendants would use this to delay the case. And since you're a plaintiff, you choose most of the time where you're filing the case. You choose the form where you're filing. And so it's a late night, and I understand that, but I've been working on this for about 5 or 6 years. And
hold on just a second. Anything further you want to give about
No,
the
Mr.
bill?
Chairman.
All right. Among the committee, any questions of the presenter? Mr. Lindsay.
Well, that's my one concern, I guess, perhaps, given the fact that I come from a more defense background, is that oftentimes
I'm the one who requests hearings, particularly pretrial hearings, and I like the general concept of your bill, but I face a lot of the same concerns that the plaintiff side does. Do you have any objections, just to say, to any party rather than any plaintiff?
I had a lot. Well, actually, when we discussed that, I got more objections from lawyers, because, particularly in divorce cases, there was a fear that in Metro Atlanta, when you file a divorce, that you're having enough trouble getting to that hearing. I heard some testimony the other day about some judicial circuits where it's taking 90 days on a real nice side. Mm-hmm. That the spouse would say, "Oh, I want the elected judge," when you finally got it to a hearing. And so, and bottom line is, I think I mean, it would be in the perfect world, I'd like to have that, but I got so much resistance when I had that part in there. This bill's gone a lot. It's changed a lot of times over 6 years. And so I finally just fell back to, okay, well, let's just go with the plaintiff and see how it works, because you are the one. And it's interesting. I have a lot of, it's amazing how many lawyers actually support this bill, but they won't come and testify in public.
Well,
and I understand that.
Maybe I'm in trouble because I just said I liked it.
Any other questions? Ms. Oliver.
This covers
Yes, it does.
A political person.
Mm-hmm.
They want somebody who's not tied to this county. That happens a lot in DeKalb.
And I understand, here the plaintiff would be able to require, but the reality is, if we're going to believe in an elected judiciary, which I believe very firmly, I've introduced bills over the years and very much supportive of that. Sometimes, the elected judge needs to hear the case. In our county years ago, whenever we had a rezoning, it was always a senior judge, so the elected judge didn't have to face the voters when he did the rezoning that produced the 400 subdivision, 400 house subdivision down the road. And I think it's, if you want an elected judiciary, I think it's important that they handle the cases if you want them to. And you might, this doesn't say that, and you get the case advanced. You bind it up with the delay of 6 or 8 months. They might say, well, I'm on a jury trial. Sorry. And so you make that choice. That's sort of the concept behind it.
Senior judges I don't know where it is in most circuits, but in my circuit are very pivotal to making anything happen, making cases move.
Mm-hmm.
Just on very routine, and then on outside county judges are very pivotal. Hilton Fuller with Brian Nichols.
Mm-hmm. Well, one of the things you can see is there's the kick out. The judge can say, well, this is an exigent circumstance, and we use that word, and we work with legislative counsel, and we went and looked it up, and it says unusual circumstance. It doesn't say no circumstance. We pulled out the Black's Law Dictionary, and that's what we came up working with legislative counsel. It's just it's not never. It's just there has to be some reason other than I don't want to. And they can, all they have to do is issue an order saying there's exigent circumstances, and there you go. The judge handles it.
Further questions? Mr. Hatfield.
I got a motion on.
We'll wait to get that. Mr. Fleming?
I like your concept that we elect these judges, and you probably ought to have one. I guess my question partially went to what Mr. Lindsay talked about any party rather than just the plaintiff. And I think your problem with that was that in divorce cases in domestic cases that would cause problems.
That's my point. I worked with a lot of language that was said that doesn't cause delay and undue delay. The problem is there's just no real easy way. In the perfect world, when you walked in the courtroom, the person that got elected would be handling the case. We have a big caseload, and we're just going to have to own up to the fact in the legislature we're going to have to hire some more judges. I think that's what the bill is for 6 new judges that came out of the Senate Judiciary Committee. We've got to find the money. There's no money in the budget. But I think that also would force us to do the right thing, which is to hire the judges that we need. We've been getting by on the cheap in our judicial system.
Couple of follow-ups, and I wasn't going to bring this up until you said this. Mm-hmm. When the budget left the House, we hired 4 new judges in there. And the Senate, are you on the Senate Appropriations Committee? 5?
We have 5.
And the Senate Appropriations Committee took that out.
I am not on Senate Appropriations. And you must understand, one of those judges was a judge from my own judicial circuit. So I've been working very actively with Senate Appropriations Committee, on which I do not serve, and unfortunately there are no members from Cobb County on the Senate Appropriations Committee, much to my dismay.
Well, I wasn't going to bring that up, but let me bring the one question I did want to ask you, and that is, and what you told Representative Oliver may solve this problem. I think it involved, back in my circuit, the clerk of court. There was involved a lawsuit involving the clerk of court, and all the judges excused themselves because obviously they worked with the clerk of court on a close basis, and a senior judge was brought in to handle it. And you think that would fall under a circumstance of extended circumstances?
I mean, to me, that's probably the best one. We can't hear it because that's that's in essence our not employee, but.
But the judge would always recuse himself.
Yeah.
Well, everybody would have to recuse themselves because they all work with the clerk, and so. But as long as you think that language covers a situation like that, I don't have a problem with it.
Well,
Mr. Lindsay.
as a matter of fact, example you raised, I spent 2 years with Judge Boniford up in Northwest Georgia dealing with Tri-State Crematory. Got to know him very well. And that's exactly the sort of situation where the judges in that area had to recuse themselves, so we had to bring in somebody senior. But in addition to my question regarding any party versus any plaintiff, is there a particular reason for limiting it to the Superior Court as opposed to also State Court?
It's actually Section 2 is State Court.
Oh, did I miss that?
It's just, yeah, it starts at the bottom of page
Oh, I
1.
see. I'm sorry. My bad. Okay. Hours late. Well, I guess getting back, I guess I'm probing here because I really would prefer it to be any party, and I think that would be
I would, at this late date, I've had a lot of work to get it to here, and part of it was the opposition. A lot of the people that are involved in the divorce area were very concerned about it. I'd be honest with you, that would have been my preference, but I just, you try to cut out where your opposition is, and I understand that. Then maybe maybe it's a drafting exercise next year that we come up with another way. If this works, we might have, it might not work, and then we might have to fix it. But I think it will, and if it doesn't work, we'll come in and fix it.
Can I ask one question on that,
Yes,
Mr. Chairman?
sir.
I mean, could you just put in there plaintiffs in, I guess that you would put in there any party in a non-domestic case and plaintiffs in a domestic case? Could you put something like that in there?
I would ask if I could defer to legislative counsel. I don't know if we can discriminate on that or not.
Well, I think your equal protection analysis, you're not invoking the protected class. On a rational basis analysis, is there a rational basis for treating?
What about access to the courts?
I'm concerned about that. We had concern if we could do this or not. We had some judges that were concerned about it, and that's why I went to.
But your concern was only to the domestic part. So if you excluded them, then you'd be left with just other cases that you didn't have a concern about.
I just know the opposite. I just know how much trouble I've had to get this far.
That's fine.
And it's been a long road of 6-7 years. I appreciate it.
Any further discussion? I'd have a question. I'm looking at the separation of power issue, which is the courts have the control of the operation of their courts, and are we by a legislative enactment interfering with that separation of power? And maybe first you, Mr. Miles, and then
well, I think courts,
look at it.
And I understand the separation of powers argument, but I also know that we require them to hear cases within so many days.
They don't do it.
They don't do it. Well, on speedy trials they do.
That's all because with the law set that they don't do it, the person walks free. They know they got to do it.
Right, and we also, by law, require them to rule in X amount of days on motions for summary judgment. They don't do it. But the law says they have to. It's as clear as can be that we oftentimes control how they run their court system. And
suppose they ignore it, what are you going to do?
Well, here you got an order. I guess you got an appealable order. You could make, and I'm sure he
could say the exigent circumstances.
I trust the judiciary. I really would defer. I trust that when they see the spirit of this, they would act that way. And our Superior Court judges, state court judges, follow the law, and I trust that they would do the right thing and just say.
We direct them to do trials on condemnation cases on a priority basis. I've got one that's been pending in Douglas County 2 years. So, back to the question: what is your thoughts about this issue on the constitutional separation?
I don't know if I have anything other than an incident here. I just think sort of like Mr. Wild. The law books full of tell judges, here's the standards on which you decide this case, on and on and on. You're constantly telling judges how to run their business in the law. My instinctive reaction, I think, is much like Mr. Wild, but that's not much more than an instinct.
Okay. Mr. Lindsay.
Can I also direct another question back to legislative counsel?
Sure.
Are we discriminating against the defendants by only allowing the plaintiffs to so direct? Which judge?
Well, that's an interesting question. It's one I know the senator has considered, and maybe he'd be a better person.
Perhaps that'd be fine.
I've it's the plaintiff chooses. I guess my argument would be the plaintiff chooses the forum. You choose whether to bring the lawsuit, whether or not to. You choose whether to bring it to Superior Court, State Court, Magistrate Court. Mm-hmm. And I think a plaintiff is different than the defendant. we have, and it just fall out. I think it's the best way to go, and it's just my gut that it's the best thing to do. This is the remedy I would prefer, and like I said, I've had addressed a lot of concerns about a lot of people about adding the other side.
Okay. Further questions of the presenter? Steve, yes, sir. Excuse me, tell me.
The element of time here, I mean, did they file it and then ask for it 6 months later, or after? Are they ever concluded for not doing it?
They're not. And the reason they're not is because I know many times I've walked in thinking I had Judge X, and I walk in and, who are you? Well,
that's true with everybody.
Yeah, and I mean, if you're a practicing attorney and you go to court a lot, and you know that's why you can't really, you know, and that's we had some discussions with the judges, and they said, well, if we put it, how about if we put it on the counter? I said, yeah, but it doesn't matter if it's on the counter or not. It says it's going to be in front of Judge so-and-so, and you walk in and you say, wait a second, I've had this other judge for 2 years. We've done all these motions, and now you're going to hear the trial? Or, okay. You know, there's a lot of reasons. A lot of times you've done a lot of stuff, and you might have to, this is not making you redo it over. They got an elected judge. They should, if you want them to handle the case, they should. That's just sort of why I fall out.
Any further questions of the presenter? Thank you, sir. Anyone else here to speak in support of or in opposition to Senate Bill 101? All right, we'll take it to the rest of the committee. Any discussion? First, let me carry on. Any discussion among the committee about the bill? Ready to entertain a motion? You have a discussion?
Just a comment. I hope if you get this thing further, that you and I can sit down and perhaps I can convince you. I'm not going to offer an amendment at this time.
Thank you.
But I do want to talk to you some further as far as we get to a floor as to whether or not we can make it for both sides. But I do worry about giving the plaintiff that much discretion and not giving it to you.
And I have, if I can respond, I have some ideas of how we could do it. It's a very complicated process, though, to put in all the standards about not delaying the case, and it's not easy drafting.
I understand. I'm not going to offer the amendment.
Thank you.
Anything further? Ready to entertain a motion? A motion from the members. Move do pass. Discussion on the motion. Any amendments to the motion? All in ready to consider the motion? All in favor of the motion signify by saying aye. Aye. Opposed, like sign? One no. All right. Motion passes.
Thank you, Mr.
I'd like
Chairman.
to ask you one other thing while you're here.
Yes.
Why did you not elect to submit a written request as everybody else does on the committee as we notified you to do?
I didn't get the notification, but I did send down a letter today, and I apologize for not doing that.
We did notify you, Monday when we got the bill in?
Yeah,
and I got a copy of the email.
I'm
That's
sure
we sent all of them.
I'm sure you did, Mr. Chairman.
Responding that way.
And I apologize.
The Senator is working very hard on my bill, doesn't the Senate?
And I apologize. I apologize.
The problem about getting my legislation through as far as just consent calendar on local legislation, which has been sitting in your committee since February the 2nd.
Which under the Senate rules requires that the senators that sign it request it.
And I sent a letter requesting, which is what I was told I need to do.
Yes, Mr. Chairman, but the Senate rules require that the senator that has the bills has to request it. And and I apologize for not getting it on the day, although I did get it on the day, and we had to, we did a special calendar, which is the first time we've done one in 2 years, so we get it on there. And I apologize, but the Senate rules do require that all the senators that have the local bill request it, and at the point until
my people are being, I say people, my aides and all were informed. I had to give a letter, which I did, and no one ever said anything different. And I really
apologize.
Got a lot of problems with trying to get simple things like local legislation through your committee, and it concerns me greatly when we see that being somehow mishandled, because that's a very delicate thing, important to all of us as legislators.
And I realize, Mr. Chairman, I just want you to emphasize that I, as a chairman, have to follow the rules of the Senate, and if I don't follow the rules of the Senate, I won't be a chairman. And the rules require that the senators have to request the bills, and until.
Well, you got this, Mr. Hill back here. Are you back here, Mr. Hill? Did you ever make a request on these bills? Well, I still cannot get a clear answer why my bills didn't get put forward much earlier, as I thought they were entitled to be.
I'm passing many bills a day, and past.
I mean, that's about what you do a day. Like I say, I'm still quizzical why my bills didn't get passed.
Yeah, they got passed today.
I appreciate that.
Thank you, Mr. Chairman.
We'll next consider Senate Bill 427. Mr. Hill, you finally got your bill up here. Sorry about the delay, but I knew it was going to be a little while on yours. You had people here of interest, and I thought the other things would be cleared out of the way rather than have them wait.
Excited to once again report, Mr. Chairman, that, and Representative Lindsay, all of us that are proud to represent portions of Sandy Springs, that was successful today, and also some of the other legislation that Representative Fleming and Lindsay have in the Senate.
Calls me to have to go to leadership to get my bills out. That's really a unpleasant thing to have to do.
Yes, sir, I understand that, and I respectfully apologize on behalf of the Senate. Mr. Chairman, if I may, I'm here on behalf of Senate Bill 427. We have a substitute, and just by way of background, if it's helpful to the committee, what got me initially interested in this are two things, maybe in no specific order. One is I have a Series 7 securities license as well as a law degree and some other licenses, and I also serve on the Senate Retirement Committee. As many of us may know, our employee retirement system, the ERS system, is under extreme financial pressure. We have about 200,000 state employees under that system, and it's under pressure, I believe, for two major reasons. The first being that the baby boomers are entering retirement year this year, which is causing the number of state retirees to swell. The ERS system has done an estimate that by 2010 we'll have almost a 20% increase in the number of state retirees. It's actually 18.2 or 3, 1 or 2 or 3%. Secondly, for the first time next year, the retirement systems in Georgia and other states will be required to account for the skyrocketing health care costs of all future state retirees. Some projections exceed $20 billion per year in a liability for both the ERS and TRS system. And those are called other post-employment benefits that are applying to all states. For those two reasons, gave me strong reasoning to present this legislation to help address, one, the huge number of retirees entering the retirement out of the ERS system over the next few years, as well as the OPEB requirements to account for the skyrocketing health care costs. Both of those will put us extreme stress on the system. Secondly, this legislation, Mr. Chairman and Representatives, opens up a proven mainstream investment class that will help keep the employee retirement system healthy. Passage of this bill gives the Pension Investment Committee access to the best options to fully diversify, as well as to wisely allocate the monies that they are entrusted to preserve. With new financial...
Coming back? I'm interrupting.
Yes, sir.
I'm getting back in here. I'm down to a minimum on a quorum. Oh, Rob, okay. People keep... Have a seat and don't leave again. Thank you. Go ahead.
Yes, sir. With these new financial pressures that I just stated, created from more retirees coupled with a higher health care costs, we needed an additional investment choice to make sure that the required investment returns, which are 7.5% a year, are achieved. And Representatives, those who lead our state pension plans, the Investment Committee, the Commission for New Georgia, Republicans and Democratic co-sponsors alike, and I was excited to have a number of Democratic co-sponsors. It was critical to the passage of the bill by 48-3 in the Senate a week or so ago. All wisely recommend that Georgia should join 42 other state pension plans and over 200 of the largest pension endowments and university endowments across our country that already allow these investment choices. This is a May legislation. It's not shall, and they may invest in this. Finally, there's, as always, several prudent safeguards, and this bill provides at least 4 of those, if not more, of these safeguards to help optimize returns. The first safeguard is very important. The ERS Investment Committee can only deploy up to 1% of the assets into alternative investments each year with a 5% overall cap. So it's 1% legging in per year, up to a 5% overall cap. Secondly, eligible fund investments must be very large, successful funds. They must be 100 million plus funds with strong track records. Third, no direct investments are allowed. They're prohibited. You can't go invest in timber. You can't go invest in hotels or anything of that nature, and any other direct investments. And fourth, though obvious, 100% of the investment returns must be reinvested into the employee retirement system. 100% must be reinvested.
That's true of all the investments, isn't it?
Yes, sir. But actually, and I'll mention the reason we did that. I was happy to have some conversations with Mr. Tom Womack, who represents Page, and he and I had a discussion, and it was my impression through our discussions when we first met that they would remain neutral towards this legislation, and he specifically had requested, and I thought it was wise to restate the obvious on page 5 at line 30 and 31. You can see that I had made the agreement to, as the chairman just asked, to restate the obvious that all the investment returns will be reinvested into the employee retirement system, and I direct your attention to page 5. Another thing that I think is very important here is the teachers' retirement system are specifically excluded, which is on page 3, beginning in line 1. So teachers are specifically excluded. GAE has taken no position on the bill; they do not oppose it, and also the chairman of the House Retirement Committee, Ben Bridges, and I have been in discussions, and I'm not sure if you have it before you, but I have a copy if you don't. He and I have discussed.
I gave you that amendment that Ben Bridges. Excuse me, interrupt. You got it.
Yes, sir.
I had it before.
I have it, and I'll be happy to also distribute a copy, if I may.
Please do. That's all right. We got these.
And Representative Bridges and I have talked, and I think he has a very wise amendment to this legislation. What he is asking for, and I join with him, and I ask you to consider an amendment on page 5, beginning at line 20. And let me state this briefly, if I may. There's some language on that amendment that you have presented to you that I want to strike and withdraw. It was drafted separately and not in coordination with Representative Chairman Bridges. But let me state, well, as you see it there, to clarify, and so there's no confusion. On the first line, beginning with the word after, I would strike after all the way on, down to the comma on line 3 at assets, comma.
All right.
Chairman Bridges and I both agree that it's wise for the retirement, the ERS system, as it relates to just alternative investments, to make an annual report, as this indicates, to back to the ERS system, as well as the governor and the chairperson of the House and Senate Retirement Committee, on the profits and losses of the these alternative investments. My proposal was to do that after 4% were deployed. If you recall, we only may do up to 1% a year, up to 5%. My thinking was to wait for 4% because of the nature of these investments and how they invest in funds. But after speaking with the chairman, I would full-heartedly support striking those words that I mentioned to you and going with the amendment he has. Mr. Brumby, that's AM 213438, which Legislative Council had already previously drafted, if that was helpful.
All right.
And Mr. Chairman, witnesses are here people are here from the governor's office as well.
We'll hear from them in just a minute.
If they
Any
may.
questions of the presenter as far as the bill? Yes, sir, Mr. Fleming.
Where do we invest the funds now?
We invest approximately I will defer to Dan Eversole, who does this on a daily basis, but it's my recollection we invest approximately 60% of the present funds. It's about a $15 billion program, employee retirement system. Employee retirement system includes all of us. It includes the judicial branch. It includes in state employees. It specifically excludes teachers if they pick up another group.
Legislation's under a different plan, isn't it?
It's a separate, LRS is a separate plan, but in terms of investments, it's in the ERS standard.
Excuse me.
So we got about $15 billion.
I mean, we buy securities.
About 60% are in equities, and 40% or so are in bonds.
Okay. So, well, I had no idea we limited it to that. I mean, it makes total sense to me that to allow the best return possible for our retirees, that we if especially if 40 other states are doing, we open it up a little bit. And why not do it for the teacher system?
The reason I would only, if you ask my personal opinion, if they came to,
they're going to get shortchanged.
If they came to members of the legislature and asked for it at some future date based on the performances of the ER system, if you choose to, in your wisdom, to pass this and the House does, then that's an option that could be looked at a later date. The investment committee is appointed, and they are experts in the industry, and they choose what they believe is in the best interest of the returns, to achieve the best returns for the ERS system as well as the TRS system. It allows them to diversify and allocate assets in a way that they think's wise based on the financial markets of the day.
Thank you. Any other questions of the presenter? Yes, sir, Mr. DeLay. I'm sorry. Come around. Yeah, you go ahead.
The 42 other states, you said this in your remarks. What has the track record been on improved performance of those investments in the states? Do we have a good handle on how they've done there?
We do, and once again I'll defer to Dan Eversole, but from what I understand, the percentage of investment of the pension plans in those states have actually almost doubled, gone from almost, as maybe 80% of those numbers are fairly accurate in the last few years because of the big successes that they've have experienced. And once again, this is a may legislation, not shall, so this is the option. We just give them another tool.
Mr. Tumlin.
I'd like to ask a question, trying to interpret page 3, C and D. The overall limit of assets is 5%. It comes at 1% increments a year. But any particular ultimate investment, the most you can have in one at one time is 20%.
That's exactly right.
I got a shake in the head by it.
Here's what we want to do, is we don't want to be the major player in one of these big investments. So we want to be no more than 20% into it. To minimize.
Okay, when you say the cap on the best, you talk about not our pool, but the pool of whoever you're investing in.
Yes, sir. Currently, 1% of $15 billion, just running the numbers, is $150 million. If we were ever to do 5% based on that $15 billion, we would be doing what, $750 million, if those numbers are accurate. But we don't want to be a dominant player in any large investment just because I'd let them speak to that. But it's a wise choice.
I didn't understand 20% of what, and that's where I was going.
It gets technical in those pages. Thank you.
Any other questions of the presenter? Thank you. Hold on, Bob, while you sit there, I'm going to follow something. I believe I'm correct about what the law is, and I was thinking through this today. Public pension plans are very different and unique in their constitutional mandates when they are set up as a different to a private sector, what we call fixed pension plan. And the difference is in a state, county, school board, municipal pension plans, you have a vested property right based upon what that plan provides that cannot be divested. It is a plan that also assures payment. If there's a need of the plan going broke, it doesn't go away. It just means you got to levy taxes to cover the cost of it. I believe that's the correct statement about it, Mr. Brumby. So, irrespective of what we do investment-wise, call it risk or non-risk, or put it in U.S. Treasuries or however, it's just still a ongoing obligation that does not change the obligation regardless of what kind of return we get on the money.
That's right. And Mr. Chairman, in the investment community, there's two types of plans, retirement plans. We all know these, but there's defined benefit plans, which is in layman's term a pension plan, which is what we're talking about here, and it does exactly what you indicated. And there's also a defined contribution plan, which is what the majority of private companies use today, and those are 401k plans.
Okay.
And those rise and fall with market returns, and pension plans have if they're going to pay you $300 a month, it's $300 a month.
So.
Yes, sir.
But we don't bankrupt or remove the plans. We may stop the plan, but the people in that plan, as far as the government sector, remain with their benefits, who were employed at any time that plan was in effect, and they had the benefit of it. So we're not really doing anything with it may cause, well, okay, sorry, employees, we lost your money, and you don't get it anymore. We just have to levy taxes if we lost the money.
And, Mr. Chairman, if I may, at the appropriate time respond there, too, is that's my motivation behind it from the first place, is because of the huge number of retirees, as well as this extra requirement.
Big bubble's coming up. We know that.
We've got a bubble.
Let's get on with the other hearings. I'm going to ask you all to try and keep your comments brief, if you would, because we do have 4 of you, I believe, or 3 of you want to talk about it. And I'm going to call first upon Mike Neff.
Second, Chairman, please.
Okay. The Employee Retirement System. Mr. Neff.
Thank you, Mr. Chairman.
Glad to have you with us.
Thank you, and members of the committee. The Employees Retirement System supports alternative investments because, number one, we believe in a fully diversified investment portfolio. And it's because we need a continuing increase in returns to meet our pension benefit needs, as the Senator has explained. Simply enough, alternative investments, we believe, it just offers another tool to give the investment professionals an opportunity to diversify the investments and to increase the overall return over time. So again, ERS supports
you all in support
alternatives.
Thank
Yes,
you. Any questions of Mr. Neff?
You know, we're often asked that question, and if you take a look at the big picture, we've earned more income in WorldCom over time than we've lost over time.
How about what's the other not Costco,
Enron.
Not Enron either. I was saying about the Cisco. That's right. That was my big one.
I don't recall.
Okay, thank you, Mr. Neff. We next have Tom Womack and Margaret Price with the Professional Association of Georgia Educators. Yes, sir, Mr. Hill.
In all due respect, I'd like to make one sentence comment before Mr. Womack comes up. I understand that they may be taking a position against it. I don't want to misrepresent that to the committee that they've always.
Well, that's fine.
And I want to say that in advance.
Right. Well, we know that. They've got a right to make their position. Come forward. Glad to have both of you with us.
I've got handouts, if you all, if that's okay with you.
All right. Mr. Womack, come on up. Why don't you do that? Why don't you give your comments so we can keep it moving, please?
Yes, sir.
You're speaking on behalf of Paige, right? This is the position of Paige?
Yes, sir.
That's your personal position.
Right.
All right.
I want to thank you, Mr. Chairman, and members of the committee for allowing us this opportunity to share with you some of our comments. You'll see the first on the letter on the first handout. It was dated February 2nd, but this letter was shared with the Senate Retirement Committee on February 9th. And I appreciate Senator Hill's comment just then with reference to the fact that somewhere along the way someone thought we were neutral. But I think the last sentence in the first paragraph and the last sentence in the letter references our position, the position that we've had since 2001 when this first came up under Governor Barnes' administration. We opposed it then, and I think if you look at the summary of the study committee that referenced the fact that that study committee did not think it was a good idea at the time. Since then, we have opposed the concept of taking retirement funds, ERS and TRS, and of course we're aware of the fact that TRS has been eliminated or removed from this Senate Bill 427. We're aware of that fact. In 2005, bills and resolutions were introduced, and we opposed it at that time. And this year, under Governor Perdue's administration and the leadership of the House and Senate, it appears that this is before us with the TRS being excluded. We still oppose the idea of opening the door with regards to the possibility of future raids on, at this point, we've had calls from, the reason we oppose, I want to make this very clear, the reason we have opposition to the ERS is under ERS, you have one group, Public School Employees Retirement System. That is made up of bus drivers, maids, janitors, cafeteria personnel. We have 65,544 members statewide in Page, and we have 1,012 members in the PSERS. So it's a matter of principle and integrity. We did not think we could just turn our back on those people. We do not know what the future might hold with regards to investments. This may be the best thing going. And we know it's a defined benefit plan. However, if it goes south, then the taxpayers in Georgia would have to pick up the tab, and we'd be concerned about that. And we've had calls from TRS members. Representative Fleming brought up an observation earlier about if this is good for ERS, why not TRS? But we've had calls from the TRS members saying why, the governor and the House and Senate, will we be next? So I think that's a concern that we have. So,
thank you, Mr. White. And again, I say the same thing that you. This, as I think you recognize, there is a fixed, absolute revenue obligation for the state to continue.
Well, we understand that.
And there's no changing that. Even if the thing went totally bankrupt.
I know, but the taxpayers would have to pick it up.
Absolutely, of which we are.
That's right, we are.
Thank you.
Thank you for your time.
Mr.
Just one quick
Yes, sir, Mr. Linden.
The advantage of being, I believe someone said that 40 other states,
42
other states have it. The advantage of being behind the curve is that you can go back and look at a track record. Have any other state pension funds faced trouble by virtue of having these kind of investments in their portfolio?
I believe that Mr. Neff could reference this probably better than I can, but I believe California's had some problems, and there's some other states that I don't have the list.
Well, that answers the question, Mr. Neff, if you know of this, if you're aware.
I know the problems California has. I had worked up in Illinois, and we had invested in alternative investments there, and the funds did as the history shows. All right. Very positive.
Never thought there would be bright California.
Thank you very much. Glad to have you with us today, Mr. Walmack and Ms. Price. Mr. Hills, of the Finance Office. Come on up, Mr. Hills.
Ask the State Treasurer, Mr. Ebersole, to share with you. We won't even sit down to take your time.
That's all right.
My interest came because this was originally a Commission for New Georgia recommendation. The business group working with the governor recommended the Public Finance Task Force. And so I worked with a committee this last year that involved the investment people in the retirement system, the two retirement systems, funding retirement systems, and state employee and retirement. The directors of those retirement systems are put on the commission for their investment expertise. The state treasurer, who chairs the investment committee of both the teachers and the teachers in the employees retirement system, and then some others knowledgeable people about investments in general and alternative investments. And what this group tried to do was, if we were going to have legislation, put together the best legislation we could that had the greatest protections for the state of Georgia employees retirement system and the other large retirement systems. And so that's the reason the bill has as Senator Hill said, legging up of recommendations. After that group then worked with various representatives, Senator Hill and others in the Senate and the House that had been interested in this legislation. And so what we think we passed is a sound bill. I would mention to you that among the other states, the other AAA rated states in the country do invest in private equity in their retirement system. And just one rebuttal to the last attachment on the sheet that Paige handed out that said Purdue questions venture capitalists. As often happens in this quoted article in the wrong context, he was asked questions about direct investment in new business, startup businesses and all, and he was replying that he didn't think that was right, and that's the way we drafted this bill. You can only do fund-to-fund type of investments, and most of it's in private equity, leverage buyouts, something similar to something like Coke buying out Georgia Pacific or Cobo Kravitz buying out RJR Nabisco. Companies that were public that we invested in as public stocks go to the private, and we can invest in the private industry through this legislation.
Thank you. Yes, sir.
Thank you, Mr. Chairman. And you're exactly right. Taking the perspective of the employer, this is a defined benefit guaranteed. What can the employer do to diversify the risk and enhance return? Looking back, Representative Tumlin, over the last 30 years, private equity has outperformed publicly traded companies by 4 to 6%. Going forward, 3% excess return is still outstanding. Let me tell you what this bill does not do. It is different than what was proposed 5 years ago. It is not Timberland. It is not extreme risk. It is not Enron. We own Enron under the existing statute. You can't screen out fraud. If somebody's going to lie, steal, and cheat, you can't screen that out. It is not TRS, but what it is a bill that has many safeguards. And already, I will not repeat them. This is a good and needed bill. It is mainstream investing. I urge your favorable adoption. Thank you.
We thank you so much.
Can I ask one quick
Yes,
question?
please, Mr. Lindsay.
Let me go to my question. I mean, are you aware we will be stating 43? Have there been any, to your knowledge, any problems with any other states that had similar investments?
Actually, California is, because of their relationship or their connections to Silicon Valley, they've actually made a lot of money, and their long-term performance has been very good. Thank you.
Thank you. Yes, sir, Mr. Tumlin.
Mathematical question. 5% of the aggregate. And then item 17 on line 31 on page 2 talks about private placement. How would you get the fair market value of those if they're not publicly traded?
That's the nature of this investment. That is an illiquid, non-marketable security. You only get the pricing when there's an event, and that is when there's a distribution, when in a buyout company, when they take the company public again, or recapitalize it, in venture capital.
Split off.
Spin off, IPO. So, right, there is no pricing until a pricing event. But the only difference between a privately placed investment pool and a private placement is just the nature of the ownership, whether we would own a percentage of the pool or a percentage of the underlying investment. So that's the only...
Yeah, but if you don't know the fair market value, how do you know you're in compliance on page 3?
On page 3.
You said you have to wait to an event.
5%. Well...
Yes, sir.
And what the top of page 4 addresses is a good problem. That is when these are illiquid, and when you have a pricing event, you can go from your original investment to 4 or 5 times extra, and then we could be above the 5%. And what that the top of page 4 does is gives a 2-year window to get back into compliance with the 5%. But that's a good problem to have because the value of the assets have risen above 5.
Let me ask this question, and this goes to the. I'm sure y'all sat down historically looking at what's happened with these other plans that have been in existence for a while. What are we doing in Georgia now as far as a rate of return on the ERS? What's the?
We're doing okay.
Well, by okay, I mean what is that amount?
Well, we need to earn 7.5% per year in order to be actuarially sound.
Okay.
We've been a little bit above, a little bit below.
But you are keeping that average pretty much.
Well, barely, just barely.
Now, what do you project this type of investment will do as far as your rate of return based upon historical other
I wish
states?
I wish I could give you a quantitative answer. It will enhance the return a little bit extra return. I can't give you. All I can say is that private equity outperforms public equity by about 4%. Okay. So only 5% of the portfolio.
Thank you.
But on a $15 billion fund, 30 basis points makes a big difference.
That does. Thank you, sir. No one else wishes to speak in support of or in opposition to the bill. It's in the rest of the committee. Do we have any discussion among the committee? No discussion. When the appropriate time is arrived, we'll take a motion. Moved, do pass, and seconded. Any discussion on the motion? Yeah, do we have any amendments? That's the oversight part, isn't it?
That's the
It
correct
is,
one,
it
Mr.
is.
Chairman.
I've got it, yeah.
Here's a copy of
I've got it. I've got it. Striking the word after and from there, because it'll read on the third Monday in January of each year, comma, the director of each large retirement system shall provide a report to the governor, etc. All right. Everybody understand the amendment? Any discussion on the amendment? All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. Any further amendments to be offered? Back to the main question. I do pass on Senate Bill 427 as amended. Committee substitute. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. We have a do pass. Thank you. I will say, Mr. Womack, I hope it's not ignoring Page in this regard, but I think this is a appropriate type of investment. It's a lot of times the fear of the unknown. We haven't experimented ourselves, but we look at others, and I think it's something that's, with the limitations we put in there, we're walking very cautiously into this area talking about it.
Well, thank you very much
too.
for your time and your
Appreciate it.
conversation.
What's 533? Oh, the living will.
Mr.
Yeah.
Chairman, thanks for that.
One more. We got one more. This is Senator Bullock's bill, I believe. Senator Bullock, you present, Mr. Tumlin. All right, thank you. Go ahead, Mr. Tumlin. Well, I had discussions with the bar, and the bar says it has been approved and reviewed and approved within the bar. And I said, if that's the case, that's been my standard. It's going to have forms. I want the bar's input.
I've got.
Yeah.
First, I'd like to offer 2387S the substitute 533. Basically, what we're changing is the form only. The original bill that Representative Oliver referred to is just dealt with the Dearborn Healthcare Power of Attorney, revocation, and other changes in Title 32. But this one is purely within the scope of the form itself.
Of the living will.
Of the living will, excuse me.
That's right.
And I'm comfortable with it, and I've talked to the hospital authority, I've talked to hospice people. They're comfortable with this, and they're all comfortable with meeting this summer to examine Title 32 and the Dearborn Healthcare Power of Attorney this summer. Right. That's not going to preclude us to go farther.
Let me ask you this question. You've incorporated what were the things you had somewhat in your bill dealing with the living will, correct?
Yeah, right.
And that was also reviewed by the bar or how?
Yes. Now, the bar, both through Tom Bowler and his crew, Mary Radford, and I'm just very active in that section of the bar myself also.
But it was not a bill or a proposal that came out of the fiduciary bar section say we, by resolution, recommend this. Am I right?
Right.
Okay, just get it straight. Any discussion among the members about the bill? Ms. Oliver? Yes, sir.
I'd like to speak to it if I may, members, just real briefly.
All right.
There's a Senate Bill 542 which relates to durable powers attorney for health care, because there's some challenges, a lot of challenges that people don't sign those in hospitals for signature reasons. And I would just concur with, and it was also supported by the Georgia Bar, Martin Middleton, and all. And I would just concur with, I believe it's appropriate to have some study during the summer months, because it makes sense to have one document as opposed to the two that are currently out there to come together. Most people are confused about the living will.
Yeah.
Go with our attorney with that.
Thank you, sir. Anyone else have thoughts or comments? You look puzzled, Ms. Albert. I'm trying to figure out what's going on up together. Tired? Okay. And I know, personally, when I do wills, I always do a package, a will, durable power of attorney, living will. And invariably, you spend more time trying to explain why you're doing, and they want you to help fill it out more and say, well, you tell me what I need to do, because they can't understand it. Just try to get some clarity to that area, frankly. All right. Do I have any further discussion? Ready to entertain a motion?
Pass.
Motion do pass. Any discussion on the motion? Any amendments to the motion? Ready to call the motion? Motion is do pass Senate Bill 533 as presented. Is this a committee substitute?
It's a committee substitute. It
is a committee substitute. House committee substitute. All in favor of the motion signify by saying aye.
Aye.
Opposed, like sign. Thank you.
That's for me.
We are ready to excuse everybody for the night. Thank you for all the time you've done, put in this year. It's been a great committee to help serve. And
I'm going to be a girl.
Yeah,
let it sit.
Well, wait, Mr. Chairman.
They all left.
Everybody talked to me about it.
I can cover this. Oh, we did. We got one tomorrow. Committee picture.
And you
We'll get Al, somehow tomorrow, we'll get a picture. You take care of that. You and Chad get in charge of that. Lord have mercy. Okay.
No, I just.
Good job, Mr. Chairman.
Thank you, Ms. Oliver.
Is that it? We through for the year, Mr. Chairman?
I think that's a true compliment coming to you. Go hand at it.